Welcome everyone. We've got Gardner here with us, and it looks like we've got a number of participants. Being a webinar, this is a newer experience for me. And so one thing I learned just a moment ago I want to share is that rather than using the chat feature, if you guys have any questions as we're going through this, go ahead and click on the bottom of the screen. You'll see a question and answer call out box. And so if you'll go ahead and type your questions in the Q&A, then I will be monitoring that to make sure that we're getting answers to as many questions as come through. I would also love each of you, if you wouldn't mind, go to the Q&A right now and just type in where you're from, whether you're with a small business or a law firm, or just give us a little bit of an introduction so that Gardner can help tailor his comments today to the kind of work that you guys are doing and the places where you're at. That would be fantastic. So I will keep an eye on that in our Q&A. But today our goal here is we're going to be covering some tips and suggestions for what businesses and employers can be doing to protect themselves. We have a lot of craziness going on in the federal government, and immigration questions are coming our way nearly every day. And because our firm does all kinds of HR, but we tend to send our immigration stuff to people who are even more experts at that than we are. And Gardner and his team over Exodus Immigration are really key partners for us. So I reached out and asked if Gardner or someone else could join us for a webinar this week, and they were happy to join us. So thanks for being here, Gardner. Gardner also has some slides that he's going to be sharing. So in a moment, when we get those slides going, you probably won't see us anymore, but I will still be keeping a close eye on the Q&A so that we can make sure we know who's here and who's joining us. So we've got a lot of people that have written on the Q&A. We've got, let's see, we've got construction. We've got small businesses that are kind of in remote or very rural parts of the state. Someone else from construction and decking company. We got baby products. We've got cabinetry and milling companies. We've got some business that I don't recognize the name. We've got some restaurant industries here too, Gardner. So a pretty good, as I'm scrolling through all the participants, a pretty good span of different businesses who are probably all needing some guidance on like what's going on with immigration these days and what can we do as business owners to make sure that we're keeping ourselves protected. So with that, I'm going to turn the time over to Gardner. I will monitor that Q&A, and if there's questions, throw them out there and I'll make sure we get them over to Gardner. So take it away.
Thanks so much, Spencer. Can you hear me okay? Perfect. Okay. Well, yeah, great to see everybody who's here. Thanks for putting a little bit about yourselves in the Q&A. It's good to know who we're talking to today. And I like people, so it's just nice to imagine all of you out there running your businesses and um, doing your thing in Utah. I'm originally from Utah. I'll give you a little background on myself before we get into this so you know who your information's coming from, and then I'll share my slides and we can get into this. Like I said, my name's Gardner Lange, grew up in Utah, and then attended the University of Texas for law school. And so started my career in immigration law down here after graduating law school, working primarily with immigrants who were children, adolescents, young adults, and helping them with their immigration court cases, helping them with their applications before USCIS, and critically helping them with work permits, which is kind of how I come to this conversation with that background of making sure that my clients were allowed to work when they had their work permit, that their employers understood their automatic work permit extensions, et cetera. So that was my background in the nonprofit space, and now lucky enough to work back in Utah with Exodus Immigration. It's kind of a homecoming for me. Really glad to be able to work now in my home state with the not only the immigrant community, but also with employers and the folks who are making their small business dreams come true. We're helping employers, excuse me, I have a little bit of a lingering cough. We're helping employers petition for their employees to have employment-based visas. And we're also happy to consult on things like compliance, which we're going to talk about today. So that's a little background on me. Thank you guys for sharing the background on you. Let me now share my slides and we'll get going. Hopefully this will be visually helpful and engaging for you. Let's see if I can share that. Okay. Does someone want to confirm for me in the chat or the Q&A that the slides are up?
The slides are looking fantastic.
Okay, perfect. Thank you, Spencer. Okay, well, what are we going to do today? Hopefully help you as employers feel prepared for what we think is going to be an aggressive immigration enforcement regime under the new administration. So we're hoping to do a deep dive into what you can do to prepare. Um, let's sort of maybe situate ourselves here in the history, and we'll look at this as we go a little deeper into the presentation as well. But if you can cast your minds back to the Bush administration, you may remember an increase in workplace raids by ICE, images on the news of suspectedly unauthorized workers being arrested en masse from employment sites. Then you may remember things being different under the Obama administration, with a focus more on audits, on making sure that your I-9s are compliant and other documents such as identity documents for employees. And then for those of you who were employers during the first Trump administration, you may remember that both of those audits and raids were scaled up massively. And for example, audits quadrupled in number over the course of the first Trump administration. So we wanted to kind of just situate ourselves in the history and in where we are today, and why you may be here today, why you may be thinking about these issues, and also just recognize that we know that you are facing potential liabilities and real risks. So that's why we're here to address those concerns and take on some questions if there are any. We recognize that this raises operational challenges in terms of making sure that your workplace is able to continue and be productive, and your employees are able to do their jobs. And it also can be an issue when it comes to your bottom line if you do end up receiving violations and fines from the government. So that's what we're hoping to do today, is to address all those concerns, and then most importantly, give you some practical, concrete steps that you can implement immediately to reduce your risk and to be prepared. So we sort of hit on this. Why does this matter? We really do expect enforcement to expand. We are already seeing an emphasis on broadening ICE's authority. And for those of us who represent individual immigrants, we're seeing that in terms of things like mandates for ICE offices to make a certain amount of arrests every day or every week or month. And ICE, frankly, has pretty broad authority also to investigate and penalize employers. And we expect that President Trump is likely to direct maximum effort and resources be given to these efforts. We recognize the financial and legal risks that you are running as employers. Civil penalties for I-9 violations can cost thousands per employee, and knowingly employing unauthorized workers or shielding unauthorized workers from immigration enforcement can carry steep fines, and in severe cases can result in criminal prosecution and potential criminal penalties. So we want to make you aware of all this. We'll go into a little more depth on the next slide about exactly the extent of the risks, but also wanted to just recognize what we said before, that your business operations are at risk. A surprise audit or raid could halt your productivity. You can imagine staffing issues may come up if you have employees who are detained by ICE. You can imagine damage to your reputation in the community if you're subject to an ICE raid and news media coverage. So I don't want to paint doom and gloom, but I just want to establish the stakes, which you all know. And especially for those of you who may be in industries like hospitality. I know we had someone mention hospitality or construction, agriculture, where we may have a large number of immigrant workers. The impact can be felt even more severely. So before we start getting into the proactive measures you can take. I wanted to just show one graphic. I don't want to alarm anyone with the numbers on the screen necessarily, as just show the trend. This is essentially showing us the increase in audits during the first Trump administration. And like I said, the Obama administration sort of increased the focus towards audits, but then things even increased exponentially, or at least very substantially, under the first Trump administration. So again, don't want to be alarmist, but I do want to just give us a visual representation that shows the likely increase in audits. I'm assuming increase in raids will be proportional, and just so that we recognize that this is going to trickle down to our communities and our businesses in Utah, where we're not immune. So, as we mentioned before, the risks and the stakes are pretty high. As you can see, I-9 forms, which are, essentially the backbone of our federal system of employment verification compliance, they can carry fines up to $2,789 per form. And you can imagine if you have dozens of employees or hundreds, that can add up really quickly. And then obviously, this is something on another level entirely in terms of the scope of the financial penalty, but knowingly hiring unauthorized workers, or harboring unauthorized workers can lead to fines up to nearly $30,000 per worker.
And Gardner, I'll just make a quick comment on that as far as like a real life experience that we ran into at our firm here. We had a really well-known business owner reach out to our firm a couple years ago. And he shared with us, he said, we are having so much trouble keeping employees. So we're just going to start hiring undocumented workers, and we're not going to do I-9s. And he said, basically, what is that going to cost us? And so we went through and like, there's a lot of costs that can add up if these important steps are not being followed, if we're not doing the I-9s, if we're knowingly hiring people who are not authorized to work here. And I think that the size of those numbers kind of convinced him that maybe that wasn't the right path to go down, because it can be devastating to a business for sure.
Yeah, absolutely. And I do want to pause too, and Spencer, I think that gives me a good opportunity to do it, and just recognize that I know that we are probably talking about individuals who you know and care about, who may have work permits from the federal government that may be expiring, or people who want to work for your company, but that they don't have proper documentation. And our goal is not to turn you away from these friends and these valuable members of our community, but just so that you are informed of the legal risk. And we know it can sound harsh at some point to say things like, be very careful about unauthorized workers, but we hope that um, we will be able to help people who are needing and deserving work permits to get them, and then for the employees to be able to, or the employers to be able to employ them. And thank you, Spencer, for laying that out. That sometimes you got to do the math, and you're opening up yourself to a pretty substantial risk of penalties. So, and then on top of the penalties, possible criminal liability for harboring, for employing unauthorized individuals. And unfortunately, there have been employers who've suffered pretty severe fines, and in extreme cases, even criminal prosecutions. So this may be the most important slide of the day. We're going to have more slides that get us into what to do if an audit does happen, or what to do if a raid does happen. But I'm hoping that we can also spend some time preparing you all to prevent that from happening, so that you can hopefully avoid an audit or a raid in the first place. So we'll spend some time here, and monitor the chat for questions. We'll take the questions at the end, but I imagine there may be a number of questions here. So we can break this down into a couple recommendations, these 3 bullet points on the screen, but the underlying principle under all of them is just preventative and proactive measures, right? No employer is going to be able to completely eliminate risk, but these steps can significantly reduce the chances of you being audited, or if an audit is inevitable just because of the increased number of audits, these steps can minimize the risk of penalties that you may face if you are audited or eventually rated. So our first recommendation is to conduct regular I-9 audits and develop a written I-9 policy. So one of the biggest targets and red flags for ICE in an audit or a raid are incomplete and incorrect I-9s. We would recommend at least every 6 to 12 months a review to try to catch things like expired work authorizations, missing signatures, or other technical errors, and to try to catch those before ICE catches them. There are ways that you can make corrections if you catch errors or technical violations before ICE does. You can make some corrections. We'll talk about what not to do. For example, don't backdate your documents, but you can note and make corrections, and that can potentially save you from liability later on. We'll talk maybe a little bit later on as well about the decision of whether to conduct these I-9 audits internally versus externally, having someone else come in and do them for you. That has to do more with the size of your business and whether you have an HR team internally. But let's shift now to talking about a written policy. So especially I think for the small business owners in the room, a written policy I think is a great safeguard for you, somewhere where you can look at what's on the paper for what you need to do with your I-9s, right? Just a checklist you can follow to help keep you in compliance. I think this would be especially important for those businesses where HR responsibilities are split between multiple people, or where an external service is providing some HR services, so that the expectations can be made clear across potential communication gaps. What do we recommend in an I-9 policy? First of all, the basics on how and when I-9s are to be completed, right? That they need to be done immediately and within the 3 days of employment. Also, steps for verifying documents to make sure that the identity documents that your new employees provide are acceptable, permissible, and legitimate. You would want to document in your policy also how to handle expiring work authorizations. You jumping in, Spencer? I'd love it if you
I
would.
did. I don't
Yeah,
mean to be
come
distracting.
on
I didn't
in.
want to get in the way of your flow, but I have a question for you, Gardner.
Yeah, of
So
course.
oftentimes we have business owners will say, somebody has given me a work authorization card or social security card or something, and it doesn't look totally legit, but they're not sure. And so what we've advised employers is your responsibility is, as you're looking at them, is to do the best you can to make sure that they are real. Like it doesn't have a taped on picture, or the colors look right. It's not like a green social security card or something. But if somebody comes across a document and it's like missing like a hologram, or it's missing raised letters on the side of it, what's your advice to them is regarding, are they obligated to go on to, a USCIS website and look up examples and see, does it look exactly like the example that's online? Or is it just, it looks legit to me and that's good enough? What do you tell people with those kinds of issues?
It's a great question. I think I will skip down to what's going to be my final tip for this slide, actually, and just say that I think the measure in a lot of these questions that are sort of edge questions, right? Like, do I do more I authenticate this document, or do I just accept it as it is? The measure for a lot of these questions for me, and I think for ICE, would be good faith. And that, for us attorneys, that's a kind of a term of art, and maybe is starting to lose its meaning because we've heard it so many times, right? But essentially, if you've made a good faith effort and you really think that it seems legitimate, then I think you document that and move forward. If you make a good faith effort and you're still unsure, um, then I would consider just reaching out to counsel if you already have counsel lined up, or reaching out to an attorney friend and saying, "Hey, could you recommend someone I talk to about this?" Um, and they can advise you on the extent of the investigation you're obligated to undergo. And then also, I would point to our third bullet point on the screen. You may be able to save yourself some of that headache of, is this legitimate or not, if you adopt E-Verify. And I'll use that as a teaser to get us down to the E-Verify point in a minute. But I think there are some considerable pros and cons to adopting E-Verify.
And before we jump into E-Verify, I just want to let you know we got a question that came through the Q&A, Gardner. Here's what it says. If an employee received his certificate of naturalization for being a U.S. citizen, is that a List A document? Or if not, where does it get recorded on an I-9? So the document being a certificate of naturalization document. Any thoughts on that?
I wish I had those lists memorized. Wouldn't that be great if they lived in my head as a PDF document? I don't know off the top of my head. But my instinct is that that's a good sign, right? A naturalized citizen has the right to work, and so
Yeah.
you're on the right track there. And apologies for not knowing exactly where that lives on the lists of verification documents.
Yeah, I'm going to pull it up and see if I can find it in the meantime while you move on to E-Verify in the next slide here.
Great. Okay, thanks, Spencer. I appreciate that. So, anything else that we want to think about putting in our I-9 policy? I think one, and this might be possibly the most important thing, is to designate who is responsible for storing and reviewing I-9s. Not only is this going to keep some accountability on, who is reviewing your I-9s and making sure they're compliant, but it also keeps you organized and keeps your I-9s readily accessible. If ICE reaches out, you're going to need to respond quickly with the I-9s. And so to have them where you know they should be, and to have them organized can make all the difference and make you less stressed in that chaos of that short turnaround period from when ICE requests the documents, when you're that 3-day period you have to respond with the documentation. Potentially, you may want to consider storing I-9s not only in your personnel files, but also separately in a separate filing cabinet or whatever it may be, in a place that's set aside just for I-9s, just to keep yourself extra organized and extra easily accessible.
And Gardner, on that point, there's another great question that came through, which is how often should the employee fill out the I-9 form? Is it once? Is it yearly? Is it something else? I believe the answer is employees just fill it out once at the beginning of their employment, and then we just keep those on file throughout their employment. Would you agree with that, or do you have a different perspective on that issue?
No, I think that's exactly right. That's exactly the advice I would give. And then employers need to maintain them for 3 years after the hire date, or 1 year after the employee leaves, whichever is later.
And then, like we talked about earlier this week, Gardner, is once in a while we run into issues where the I-9 forms are being prepared and stored electronically. And sometimes they are lost either through a third-party vendor's fault or sometimes through the company's fault. And in those kinds of situations, our advice has been, and I think that we're on the same page on this, on if we're missing the data, it's appropriate to go back and recollect that data as long as you're doing it for everyone. We're not just identifying certain individuals.
Exactly. I think that's the key, right? If you find yourself with missing documentation, you want to be careful not to appear to be discriminatorily asking for new I-9s from employees who have a last name that sounds like they're from another country or something, right? So I would suggest you document what happened. You could, write up a memo that says, hey, our third party vendor lost our digital I-9s, or they deleted them contrary to our policy. And our next step as a company is to um, request across the board new I-9s from our employees, so that we can maintain compliance.
exactly.
Yeah, that unfortunately can happen with a third-party HR provider or a third-party vendor. But ultimately, you as employers are legally on the hook. Unfortunately, that's not somewhere where you can pass the buck on the responsibility. Okay, so let's talk about the second bullet point, training. The training you want to do for your HR team or your managers or for yourself, if you are the business owner and the HR team and the manager, you want to start with your written policy, right? Make sure that those folks know what's in the policy, who's responsible for what. For those of you who are saying, yeah, I am the HR department for my small business, I can hear you saying things like, well, I don't have time for audits. We don't hire very often. Why do we need training? Um, I think in terms of those concerns, you may want to make time, make time for the audit, and you can simplify it. You can simplify it down to a checklist, or you can bring in an outside helper, whether it's an immigration attorney, an employment attorney, or some other compliance specialist. Um, But even if it's a small operation, making sure that those who touch hiring and HR have access to this written policy and are checking and reviewing forms, I think that can prevent errors and save you from liability in the future. Okay, so let's talk about E-Verify. For those of you who aren't familiar, E-Verify is a tool where essentially you are sort of cross-referencing your employees' verification documents against government databases from the Department of Homeland Security or the Social Security Administration. This is not a federal requirement. It is required by some states and in some cases where you have federal contracts and contractors. But the reason I put it on here is because it can be really beneficial, but it also may become mandatory. So that's the first reason I would say to consider um, adopting E-Verify is that the Trump administration has signaled um, support for E-Verify and a possible nationwide mandate to participate in E-Verify. So if that is the case, getting ahead of the curve and adopting E-Verify before it's required may help the transition be a little more smooth and avoid it being rushed and stressful and also causing potential problems. Other reasons to adopt E-Verify, because the government does favor and support it, it does add to your list of things that you've done to show good faith compliance. It can reduce the risk of hiring unauthorized workers because it does give you that extra cross check of employee information with the federal government databases. So you're less likely to unwittingly hire someone who shouldn't be hired. And then it can also be a time saver. It can speed the hiring process along if you're able to verify quickly. And usually E-Verify results come back quickly. Now there may be reasons to not adopt E-Verify specific to you and your business. Um, for one, it's not foolproof. Ultimately, the employer is responsible for I-9 compliance and document compliance, and there have been instances where, because the records in the federal government databases are outdated or mismatched, that people who should have the right to work are given what's called a tentative non-confirmation from E-Verify. Um, Now, those tentative non-confirmations also bring up a strict follow-up requirements. You need to inform the employees immediately, provide them a copy of the notice that they weren't confirmed as authorized to work. And then the employee gets 8 days to resolve the issue with those federal databases. If you fail to follow those procedures, you open yourself up to unfair employment practices claims. And then if the employee doesn't take action, you're also put in an awkward situation of having to terminate that employee if they don't take action on their tentative non-confirmation. So it can be an added administrative burden. If you don't feel like your team has the bandwidth or the personnel to respond quickly to these tentative non-confirmations, E-Verify may not be right for you. Um, And then keep in mind with E-Verify, and Spencer hinted at this, but you need to apply E-Verify and I-9 compliance broadly and not targetedly at individuals. And not just asking only certain employees to use E-Verify and others, you're just accepting their documents. That can open you up to discrimination claims.
So I see it more of it's an across the board thing. If my employer clients are going to adopt E-Verify, they use it for everybody, for all of their hires going forward. And it's something once you start, you got to stick with it. So it is an obligation for sure.
Yes, exactly. I second that. Okay, so hopefully these measures can help you feel like you're sort of building up your case, that you're attempting compliance in good faith. Um, the more you can show good faith efforts, the more likely the government may be willing to be lenient if they do find, even if they do find compliance errors. So let's talk a little bit more before we get into what to do if you're audited and what to do if you're rated. Let's talk a little bit more about what these preemptive measures could look like, especially with the I-9 audits. So, um, common mistakes. Oftentimes, what ICE identifies and fines you for are incomplete forms, whether that's just leaving one field um, blank or, importantly, missing deadlines if you don't get your I-9s in on time with your new hires and your onboarding process. Maybe you are using an onboarding software and you thought you filled out the I-9, but the onboarding software never ended up getting the signature from your new employee, or your employee didn't date it when they signed it. Little things that are easy to overlook. Another one, there are a lot of outdated versions of things online because everything exists forever on the internet. So make sure you're using the current version of the I-9. And look out for incorrect supporting documents, like we were talking about before, making sure that the supporting documents your employees submit are appropriate.
Gardner, I've got a quick question from Savannah, which I think is spot on here. She asks if utilizing E-Verify and an employee is approved, but during the audit there's an issue found, where does the liability lay? My understanding, but I'd love your take on this, is as long as the employer is using E-Verify the way it's supposed to be used and you're running all your employees through it, if there is a problem, like maybe a document is approved, but it is maybe there is actually something wrong with the document, the E-Verify program in using it appropriately gives the employer some level of protection, because they're relying essentially on I don't know what the database is that E-Verify relies upon, but that is kind of taking liability off of the employer's shoulders and is putting it elsewhere. Is that right?
I believe that liability technically still lies with the employer, like compliance technically still lies with you as the employer. However, I think you're much more likely to be treated leniently, like I said before. Like if ICE were to come in and see that, but see that you were using E-Verify and that E-Verify gave it the green light, I think that's a really strong point to make to ICE, and whether you make that yourself or you have your legal counsel brief that and explain it to ICE in a legal memo. I think that is a level of protection, if not complete absolution from liability.
Sure.
Thanks, Spencer, and thanks for the question. Okay, internal versus external audits. I think this is going to just be up to you guys as employers to determine what makes the most sense, right? We mentioned before, there are folks that can help with this. Compliance professionals, agencies, immigration attorneys, employment attorneys, um, are all capable and able to assist in these kind of I-9 audits. But maybe if you're a really small operation, you run that yourself. And I think that will be up to each of you. Excuse me, sorry, I just lost my slides. So let me try to reload them. Did you
While
lose
you're
them too?
No, I still see them on my end, but I'm gonna see if I can make you do some multitasking here for a minute, Gardner.
Okay, let's do it.
Another great question came in. It says, if we realize that there's an error on an I-9, how long can we take to fix the issue? And then there's a second part. Or if we're doing an I-9 audit, how long do we give the employee to refill out the document? The time, kind of a timeliness question there. Your thoughts on that?
Yeah, I think there's nothing that I'm aware of in the statutes that tells you a specific number of business days to make a correction there. So I think that's just a matter of um, showing that there's not unreasonable delay in making those corrections. If there's a delay of a week or two because you're getting in touch with your counsel and your counsel's taking time to form a legal opinion on how to go about correcting it, then I think that's something that you're well within your rights to do is to consult with your counsel, or if you need to give the employee some time and your employee gets sick for a few days. I don't think that is outside the realm of what's reasonable.
Sure. Thank you.
Yeah, so I would go back to another one of those legal catchphrases. Was it reasonable?
Or that's right. Or avoiding any kind of unreasonable delay.
Exactly. That's what I would suggest there. Good question. Thanks, Spencer. Okay, let's talk about what happens if you do get audited. So, I'm going to jump ahead one slide and then we'll come back to this. But the first thing you're going to get if you're getting audited is what's called this notice of inspection. So that's what we're talking about right now is if you've received that notice of inspection and ICE says, hey, we're going to audit you, what's next? We'll go back to that flow chart in a minute and kind of talk our way through it. And hopefully that will be a helpful visual. But the first thing is if you haven't already, now's the time to get legal counsel to represent you. You only have 3 days to respond to ICE. And so it really is advisable to already have counsel lined up, whether you're already paying them or you have an understanding, a retainer agreement with an attorney to represent you. One of the benefits of having counsel already on board is that you can designate them as a point of contact. You can train managers and others to respectfully direct government agencies and emails to your counsel rather than responding directly to questions themselves. Also, if we get to the point where fines are being issued, you're going to want counsel to navigate the process of negotiating those fines down or challenging them all the way at a hearing if need be. And that really is a job for legal counsel as you guys are trying to focus on running your businesses. Next, comply. You need to comply, but you also need to know your rights. So ICE is going to request things like I-9s, right? And may also request things like the identification documents that your employees provided and other public business records. Those you need to provide and provide swiftly. But outside of that, if they're asking for more information, whether it be payroll records or tax documents, they may need a subpoena or a warrant. So this is where you want to consult with your counsel again, see what ICE is legally allowed to request. And also importantly, always request that any communications from ICE regarding their requests are made in writing so that you have a clear record of what's being asked and what you're providing.
And Gardner, I'll chime in on that because we deal with a lot of different government agencies, federal agencies and state agencies. And there are different rules that govern what kind of information they have a right to access and to get copies of. And so whenever a government investigator or auditor is either showing up at your door or sending a letter about a potential meeting, that's always a really good time to bring in your legal counsel right away. I want to ask another question here that came through the chat, if you don't mind, Gardner.
No, please.
What happens when a current employee that has passed E-Verify and completed their I-9 changes their documentation or immigration status? Does the employee need to update or redo their I-9 at that point?
I don't believe so. I'm thinking of someone, for example, who, is here on a visa, they have a work permit, or let's say they have an asylum application pending and they have a work permit, and then they're able to succeed in their immigration case and get a green card, right? Or some other change of status. Maybe they have married a US citizen and they're attempting to adjust status to a legal permanent resident through their marriage. I will double check this because there's a small percentage of doubt in the back of my mind, but my memory and my instinct is that um, there's not a need to restart and refile the I-9, that the original I-9 is sufficient.
Sure. And for Nicole, who is the who got asked that great question here, I would just suggest, if these are more than just a hypothetical question, but if they are specific about a situation that any of these businesses are dealing with, that, at the end we'll for sure have Gardner, explain the best way to get in touch with him and his team so that you can get, real specific answers on some of these detailed questions.
Yeah, and apologies in advance if any of these questions need to be taken under advisement for follow-up, but that's something I'm really happy to do, is be in touch with y'all going forward to follow up on some more specific questions. So yes, we'll share the contact information. Okay, so the last thing on this second bullet point that I wanted to say is don't overshare. If ICE requests X, Y, and Z documents, just give them X, Y, and Z. Don't also give them A, B, C, and D. You may have the instincts to just share everything because we didn't do anything wrong and we want to be transparent, but you may not realize that document A and B accidentally do have some little errors, and you don't want to open yourself up to additional liability. So this is also a good time to conduct an internal review, right? Once you realize that ICE is auditing you, it makes sense to do a little bit of a self-audit too, whether that's internal or external, like we spoke about before. Look for missing forms, incomplete sections, errors, and then correct what can be legally corrected. Again, never backdate your forms. Never try to make an I-9 look like it was correct 2 years ago when it really was just made yesterday. And then if forms are missing entirely, we kind of discussed that earlier, right? That's an opportunity to probably to contact your legal counsel and see how best to handle that. I would suggest, not trying to falsify or make it look like you had the document when you didn't. Better to just note what you learned and any efforts to correct it.
So honesty is the best policy, right?
Exactly.
Yeah, I often will tell our clients that they may want to say something or do something to try to make their case better. But if it's not totally honest, it usually is going to backfire on them. So even if you've missed something, you missed a deadline, you missed a document, it's best to just going forward, correct it, but not try to change it for the past. Another question came in, Gardner, I wanted to run by you. Should we
Yeah.
keep copies of those supporting documents with their I-9s? So sometimes, of course, not keeping the originals, but sometimes employers will make a copy of the passport or the driver's license and the social security card or whatnot. What
Hmm.
advice do you have for business owners here when when they or their HR teams are completing the I-9s? Should they just inspect and make sure the documents look legitimate and return them? Should they be making paper copies and keeping them in the file? What would you say?
I think a paper copy, keeping it in the file, is best practices. That's what I would suggest. You have a right to review that document, and so you can keep it in their personnel file or in that separate file we talked about that you have prepared just in case of an audit or a raid. I think that's wise. So I think it's a great question.
Wonderful.
Okay. Those are our first steps if you're receive that notice of an intent to inspect. So let's look now at what comes next. So you've received this notice of inspection. You've contacted your lawyer. You've done a little internal review. You've made sure that ICE actually does have the authority to request what they're requesting. Next, ICE is going to inspect your forms. They may notify you of any suspect documentation, of any discrepancies that they find, but I've also heard of instances where the notification did not come through, and instead the next notification they got was just a notification of violations. And then, oh, excuse me, wrong slide here. Um, the notification that there's a notification of intent to fine. So hopefully what we hope happens is that after inspection, we get no violations and then compliance, right? And you've passed with flying colors. However, it's likely that there may be technical violations or even some small substantive violations. And so we get down to this part where I think legal counsel is going to be especially important. If you get off with a warning notice, great. But my instinct is that these warning notices are more likely to happen if you have counsel going to bat for you and documenting and showing to ICE that all of your good faith efforts and that you'd be less likely to get off with a warning without having someone to argue for you. If you get a notice that ICE intends to fine you, this is a time to again sit down with your attorney and discuss, okay, do we want to fight this? Do we feel pretty strongly that we weren't in violation? Do we feel good about our audits and our compliance? If so, maybe you want to take it to a hearing and really fight it tooth and nail to the end. But if you feel like, yeah, actually there were some violations, probably some oversights, this is when you want to talk about trying to maybe settle it, trying to, come to an agreement with ICE that hopefully will reduce their initial fine amounts. So hopefully this visual helps you guys kind of think through what this whole process would look like. So this is our last slide before Q&A. Spencer, jump in before we start talking about raids.
Yeah, one other comment was just mentioned in the Q&A I wanted to share. Savannah had pulled up a little bit of research that she shared a link with me, and her comment was, employers must re-verify an employee's work authorization document if it has an expiration date.
Yes, this is true. So, and forgive me if I misunderstood the question previously. If a work authorization, it's called an employment authorization document, is issued to an employee, that will likely have an expiration date. Sometimes they're 2-year documents, sometimes 4, and those need to be renewed in order for employees to have the right to continue to work. So those do need to be reviewed. Um, there is some need to exercise a little bit of caution and not always go strictly by the date that's on the card because some some immigration cases can give the employee an automatic extension of their work permit, which doesn't come in the form of a new card with a new expiration date. It is sort of cobbled together with their old card and a notice from the government. And so that's something to look out for is if an employee comes or if you're trying to, speak to an employee about their new work authorization because their old one has expired and they say something like, no, I have an automatic extension. That's not out of the realm of possibility. Those do exist, and you just need to ask to see the appropriate documentation. And USCIS actually has a pretty good website that can explain this, and we can provide that later when we kind of send out a follow-up. But there are notices from USCIS that combined with the expired work authorization essentially form an automatic extension. And those can be 1-year extensions or 540-day extensions, depending on the case. So great clarification. Thank you. Okay, let's talk about the other worst case scenario other than an audit, a raid. So what happens if ICE shows up to your work site, to your premises? First thing to do, stay calm and contact your point of contact. Before this happens, all you employers should designate who's going to be your point of contact if this happens. This could be your attorney, could be your HR manager, could be the business owner, whoever is, trained and ready to handle this situation. If ICE shows up, the first call is to this person. And this person's first ask should be to see a warrant. Again, ICE we'll get back into this in the next bullet point, but ICE can't just search everything everywhere all at once. They need to have a warrant, specifically a judicial warrant, to search non-public areas. So this person is going to want to say something along the lines of, we will not obstruct your lawful efforts, but I need to see a warrant before allowing you access to any non-public areas. And I will contact our legal counsel immediately to help facilitate our communication today while you're here. Another tip is to maybe have this person who's going to be the point of contact be someone who has media training. Obviously, an ICE raid, if the media show up and are filming outside your place of business, could do damage in the community to your reputation. And so having someone who's a media trained point of contact, I think is really advisable. You could also just direct the media to speak with your counsel, your lawyer as your representative. Lawyers are pretty good about, keeping it close to the vest and not saying anything that would expose you to additional liability. Okay, so I've already hinted at the warrant and asking for the warrant, so you can see what the scope of ICE's authority is. But again, ICE needs a judicial warrant signed by a judge to search non-public areas of your workplace. Non-public areas, what are we talking about? For example, if we're thinking about a restaurant, there's the front of the house where the customers are, right? And then there's the back where food is prepared and cooked and employees may have a break room, something like that. That's a good guideline to think about public versus non-public areas of a work site. If ICE only presents an administrative warrant issued by the Department of Homeland Security, that does not authorize them to enter into non-public spaces. And as you as employers or the HR manager, whoever's there, you do not have to grant access to those non-public areas based on an administrative warrant alone. Okay, number 3 is probably the most important here, is to not obstruct. Obviously, I'm giving you counsel as well on making sure that ICE stays within the limits of their warrant, but importantly, make sure that you're not obstructing ICE's investigations. Once it's clear that they have a proper warrant, employers can't get in the way of ICE's searches of areas that are covered within the scope of that warrant. If an ICE agent searches somewhere and then detains someone or arrests an employee, employers need to be trained to not obstruct that. We can talk about what you can tell your employees in advance, but in the moment, the advisable thing to do would be to simply note the names of those taken into custody and confirm whether or not they worked for you at your company. Because otherwise, you may be opening yourself up to harboring. Harboring is where you knowingly help unauthorized workers evade detection or escape enforcement. So that could include hiding people, directing them to lock themselves in a room or to flee. It can also include providing false information about an employee, like lying to ICE agents about someone's immigration status or their identity. It can go into documents too. If you are destroying a document or shredding something or hiding an employment record, that can be seen as harboring as well. So rather than warning and telling people to run and hide, what you can do is advise workers to exercise their right to remain silent. I think that's the most effective tool against employees being detained, is them knowing that they have the right to remain silent if ICE shows up in a raid. But this is something that should be done beforehand and not in the moment. If you're seen to be interfering in the moment with ICE's questioning by telling people to remain silent, that could be interpreted as harboring or attempting to shield them from enforcement. So don't interfere, don't coach them in the moment on what to say, but advise them beforehand they have the right to remain silent. And in terms of records, keep your employment records organized and accessible. If they're shuffled around or hidden in different drawers, that could open you up to, ICE assuming that you're trying to hide something. Okay, so then finally, while you may feel a little helpless in the situation watching ICE search your work premises, you have the power to document everything that's happening. Write down what the agents do, what they take, who they question. If any employees are detained, like I said, note their name. And as another tip on documentation, remember that filming public officials is First Amendment protected activity. So you can film an ICE agent during a raid and film what they're doing. Don't attempt to conceal the fact that you're filming either. That just stand on that as your First Amendment protected right.
And that's why I turned my video on. I was going to ask for your opinion on recording because I imagine following government agents around while they're arresting people and trying to write it out like an old school reporter is probably not going to be very effective. So recording is the best way to do it.
Yes, yes. I would, if that were me in that situation, I would pull out my phone and start recording.
Exactly.
And they may tell you, stop recording. You can't record us. Not true. That's something where if your lawyer's on site with you, which if you can get your lawyer to show up and be on site with you during a raid, great, right? But us as attorneys would go to bat for you to defend that right that you have. As a First Amendment protected activity to film public officials, including ICE agents. So those are the recommendations for an audit or for a raid, excuse me. We've gone through recommendations for an audit. We've gone through preventative measures to try to avoid those in the first place, and we've reviewed the stakes. That's everything I have in terms of slides and content. So I apologize that we only have a few minutes left for questions, but if there are more in the chat, Spencer, let's hear them and try to answer them while we still have a few minutes.
I was going to say it's so great is people have been chiming in with questions all the way through. So we've covered everything. I had one more that just barely came in. But before we wrap up, let me just say most of the attendees that are on our webinar today, Gardner, are clients or at least connections with my firm, Employer Lawyer. We send out a weekly HR newsletter to our clients and kind of update them on important things that are happening with employment law. But a lot of these people may be new to you and to Exodus Immigration. So before we wrap up, and we've got two questions here. What is the best way for people to reach out to you if they've got ongoing immigration support needs?
Great question. Um, you can reach out to Spencer for one, and he can give you my personal email and contact, and I'm happy to share that in the chat here too, if people can see that. But if you're looking for us online, Exodus Immigration Law Utah, and we have a number on there that will connect you through for a free consultation. We're very happy to sit down with people just to help them understand where to get started. Even if you don't end up working with us, we're happy to help you get your bearings and send you in the right direction. We're happy to help you with these compliance kind of issues, or also with individual employees that you may have who want to switch from one type of visa to another, or whatever the case may be. So get a hold of us there through our website, Exodus Immigration Law, and my information should be available as well, and our
Sure.
phone number is there to call anytime.
And I'm looking at the chat now. We got a few additional questions that have come in we've had a few dozen attendees on the call today. So I'm really glad we've been doing this. It's such an important issue. I will say before we wrap up, though, this is being recorded. So anyone is welcome to reach out to me and my team at Employer Lawyer. Let us know if you'd like a copy of like a link so you can go back and watch the recording of the webinar. We're happy to share that with anyone. And so if you do need to drop off before we finish these last few questions, just know that you can get a recording if you just want to reach out. Okay, so we got three more questions here. You ready to go through these, Gardner?
Let's do it. Rapid fire.
Here we go. The first one, how much is the employer held responsible if a contractor or a temp agency used does not verify work authorization? And then in parentheses, we have a contract in place that stipulates that they must verify the work authorization.
Hmm. That's interesting. If you have that contract in place, I don't know how that would play out in if you were to litigate that and actually, attempt to hold them responsible. But generally, the understanding is that employers maintain that responsibility and that liability. But this would be an area to make an argument for yourself and show that you made a good faith efforts and that you tried to establish responsibility and accountability in that contract, so that could potentially be a mitigating factor as well.
And I might just suggest that for employers or businesses that have a lot of work performed by subcontractors and others, I mean, now everyone that's been on this webinar knows a lot more about immigration and I-9 enforcement and all that kind of stuff. So they might just, work more closely with some of their subcontractors and make sure that they've got proper, procedures in place to make sure that the the immigration side of the business is, we're addressing all of these issues that we've been talking about today.
Yeah,
Um,
ask for a meeting to train them on your I-9 policy.
yeah, for sure. Okay, the next one here, are penalties and administrative decisions posted publicly similar to the way that OSHA violations are posted?
That is a good question. I will be honest, I don't know.
Yeah, I
Um,
don't know. I
I'd
haven't
have to
seen them
get
before.
back to you on that question.
Yeah, if there is a place, here's the thing, we got an employment lawyer and an immigration lawyer here, who neither of us are aware that they actually post those administrative decisions and penalties publicly, which means that if they are public in some way, most people probably don't know about it anyways, right? But yeah, it's certainly not something that I've been made aware of. I know like when the Department of Labor or the EEOC makes a determination or a settlement of a big case, they'll always post it right on their main webpage. And so, a lot of people do see those things. Okay, a few more questions here coming in. Um, what if someone gave documents when they were hired, but then some months later they come back and say that their real documents have come through and they want to be rehired with new information? And both the original docs and the new ones look legit. We've seen this a few times. Sometimes the old documents are not legit, but you would never know it. They've been, made so well. But now they've got the proper documentation and they actually want to be hired under their actual legal name. What do you tell people like that, Gardner?
I'll turn it back on you, Spencer. What have you told people in the past?
Yeah, my advice has been if they've let you know that they've essentially been lying in the past and that their name that they were using before is a cousin's name or a made up name or something, but now they're legit, like they've got the legit documents, they've got everything they need, and they are authorized to work here. I had them redo a new I-9 with the corrected
Hmm.
information.
Yeah.
Yeah.
I think documentation of the situation too. Like you said before, honesty is the best policy. Making yourself a quick memo that says, here's what we understood to be the case, and here's what we've now learned, and that we good faith believed the documentation was legitimate before, and now we know that it is. I think that also is advisable.
And I think if the employer decides, listen, you have been, if the employer tells the employee, you've been dishonest with us and we just don't support dishonesty, I would think that they probably are on legitimate grounds to terminate for as an at-will employee, not based on their immigration status, but just based on that they were dishonest previously. So just
I
because
would
new
think so
information is
too.
presented doesn't mean you need to necessarily keep employing that person.
Yeah, it doesn't
Okay.
mean you're locked in.
A couple more coming in here. What kind of warrant with USCIS did you say that we should not accept?
That would be an administrative warrant. You would want to look for who issued the warrant. If it has the name of a judge and it's signed by a judge, that's a judicial warrant. That's the more authoritative one. But if it's not signed by a judge, if it's signed by an official from the Department of Homeland Security, that's an administrative warrant. And that does not, by itself, give ICE authority to search a non-public space at your worksite.
Excellent. And we're just a couple minutes over. You mind if we do one more here?
Let's do it.
After 3 years, do we have them fill it out again? So I think the context is we've got an I-9 completed within the first 3 days of employment, like it's required by law.
Hmm.
We're expected as employers to keep them on file for at least 3 years. Is there a need to refill them out after 3 years? My answer would be no. Not unless there's, they come to you and said they were using their sister's name and now it's their real name. As there's not a need to go back and refill them out every 3 years. Agreed?
Agreed. Yeah, if you want to keep them, I mean, no one's stopping you from keeping them longer than the 3 years, but that is the length of time required by the law.
And then Gardner, other than ICE, are there other government agencies that have authority to come in and do an audit? Maybe it wouldn't be ICE, but who has authority to do the I-9 audits?
Well, it's ICE.
It's okay.
And then, but one thing to be aware of is just like the levels of agencies. ICE is sort of a sub agency of the Department of Homeland Security, right? So it's important to just be familiar with that nomenclature, right? If you see something that says, "Oh, Department of Homeland Security," and you think, "Oh, well, that's not ICE. They don't have authority to investigate or audit me." Yeah, they do, right? It's just it's labeled as something from the department level rather than on the the lower level of specificity of ICE itself. So familiarizing yourself just with the basic outlines of those agencies and where they fit in the federal government would be advisable.
And then one other clarification that just came in from one of the attorneys on our team here. The I-9 form, let's see here. Employers must retain Form I-9 for each employee for the longer of the following two periods: 3 years after the employee's hire date or 1 year after the employee's termination date. I think that's consistent with some of what we discussed a little bit earlier this afternoon.
Yes, yeah, and apologies if I just misspoke just now, but yes, we did mention that earlier. That's the correct. It's the later of those two dates.
Yeah, perfect. Well, we are going to wrap up. We're just a few minutes over time. Gardner, thank you again for coming and sharing your expertise with us, making some time today to talk about these important issues. And hopefully, everyone, and we've had, I think, about 25 or something around that have attended today. So they've hopefully learned a lot and have a new connection with you if they've got immigration questions in the future.
Very happy to do it. Thanks for the invite, and we look forward to being in touch with y'all going forward for follow-up questions or consultations. We look forward to it and wish you the best of luck.
Awesome. Great. Thanks so much, Gardner.
Thanks, Spencer.
Thanks everyone for attending. We appreciate y'all.